to deal with COVID-19. Do you feel the government has adequately addressed the needs of people living with disabilities in its strategy to deal with COVID-19? I am at Trix Ingado, Michael's at Michael G. Gitonga, and the official hashtag is KTN Morning Express. Get on Twitter, tell us what you think, and we will be sampling your views as the show goes along. But for now, over to you, Michael.
Thank you very much. And just to look at some of the responses from that particular question that you've asked, and Trix Ingado is going to be hosting Honorable Danita Gatti later on just to delve into this. But we have Wamoyo Mushiru, who says the government was not ready for the virus. They thought COVID is just a passing cloud. We have well, somebody John, who says that we are sitting on a time bomb. I'm not sure if that is in direct reference to the question. We have Korir Lenny, who says not at all. Keep your comments coming, and we shall keep reading them as we go along. But for now, we want to look at something different. And we do know that one of the areas that has been heavily affected is in matters to do with courts. And if for anyone who may have a pending issue in court, you do know that courts are not now taking session, and this is of course in line with the Ministry of Health advisory that there should be no gathering. Now we do know the nature of our courts is such that people will come together, you'll have a judge, you'll have everybody who is involved in that particular matter gathering, but that has been stopped. However, the Chief Justice is on record as blaming some, legal practitioners of taking advantage of COVID-19 not to execute their duties. And he has come out literally, cracking the whip and saying that this must not stop. So joining me this morning, I have Duncan Okach, who is an advocate who's going to be delving into this. So Duncan, welcome to the studio and thank you for joining us. First of all, maybe to start with you, do you agree with the CJ's sentiments that there are some people who possibly, to use his words, sabotaging the process and blaming COVID-19 for the delays?
Thank you so much for having me. I may not agree entirely with that particular statement based on the fact that this pandemic came without any notice whatsoever, and every sector of the economy, including the judiciary, was not prepared for it. So that the approach that the CJ took on the 15th day of March 2020 was to order for a total shutdown of the judiciary, so that all services, without open courts, without any directions in terms of how matters will be handled, these officers didn't have any other choice but to comply, especially because it touches on their own safety. So that by the time the judiciary and the National Council on Administration of Justice was trying to find a framework of how to slowly upscale the services, there was still total confusion. People were working from home. It is uncoordinated. We didn't know what was to happen to matters which were supposed to be happening. And each court and each court registry and the deputy registrars were making independent decisions based on what they were seeing on the ground. There was no coordination at all.
All right, so of course, it's understandable that there had to be action taken and gathering cannot be allowed in any form or way given what we are dealing with. However, we would have expected that by now things maybe have taken some shape or order, or we would assume that the CJ, to be cracking the whip like he is, there must be surely some form of order or direction given as to how this is supposed to pan out.
Indeed, that is what the Law Society of Kenya has been indicating in their protests, to such an extent that, yes, we all understand that decision that had to be taken, knowing very well the nature and the setup of our courts. And actually, most of them are actually not very well structured to accommodate these directives that have been given. Be that as it may, the duration that it has taken from the 15th day of March to, let's say, 2 weeks ago or a week ago, will be seen as a bit too long. The framers of our constitution and constitutions worldwide have never envisaged that the judiciary will not be functioning. The doors of the judiciaries do not have locks, do not have padlocks, because at any given point in time, people will want to access justice. Any law that is being implemented, any directive by the government, as you saw what LSK did, could actually raise issues whereby there is need to have courts to intervene. And that is the central purpose of the judiciary, so that even if this pandemic afflicted us in a surprise mode as it did, it does not then mean that we would have gone back and closed these doors for quite an extensive period. You saw that after those particular protests, at least things are now shaping up. And I can tell you for a fact, as a practitioner, we are having courts which are now going on through Zoom technology, through technologies in Microsoft technologies, so that and Skype. And that happens every day. Today I have 2 matters, and I'll be attending court, and these matters will be handled. One thing I will want to tell you is that the judiciary, there was a trend of trying to digitize judicial services, which unfortunately did not go very far, because you had the issues that were there in terms of financing the judiciary, the wars that have been there, and it now has come back to affect us in a very big way, because if we had digitized these particular services, let me tell you, the doors of the courts will never have been locked, because we would have still continued as usual. All right,
so where we are now, what would you tell Kenyans in terms of what should we expect? Because we have LSK, up in arms saying that the judiciary is literally just using a barrage of excuses. We have the CJ cracking the whip. But, what would you tell Kenyans in terms of what to expect?
What I will tell Kenyans in terms of what to expect is that from where I sit, is that there is a coordinated effort to ensure that these services resume. They may not resume in the ordinary manner as soon as we may expect, but at least as we speak, both sides, both the LSK, the National Council on Administration of Justice, are really working hard to ensure that services can still proceed. People can file their cases can be heard within the parameters that have been set, safety parameters that have been set, both looking at the judiciary and the judges and the magistrates and the judicial staff, and also looking at the advocates, because it's not only one side that will be exposed. Everyone will be exposed, including the common mwananchi, who day in, day out will access these courts for certain services, to hear their cases, or even to deal with cases where they have actually been accused. So that it is what we are trying to see, and what we are trying to come up with is a harmonized way where LSK and the National Council on Administration of Justice will work in tandem for the benefit of justice.
Now, some judicial officers, have blamed you lawyers, and they say that this is because they cannot, for example, this is an example that they gave, and they gave this on an anonymity that they didn't want to be quoted, but they gave examples and says that we cannot force lawyers to receive judgments by mail. Is that true necessarily, or is there a problem with receiving, for instance, judgments via mail?
There is a problem, and that actually spells out the difficulties that both the judiciary and even the law society finds itself in. The laws are there, and they guide each and every aspect of the judicial process. Delivery of judgments is a critical part of any case that is being handled by a judge.
Correct.
And the law is very clear that you have to deliver it in open court. You have to give notice to the lawyers and to the parties, because there are other applications that may be made immediately after the delivery of these particular rulings and judgments, which are central to the justice that these particular litigants are seeking. Without a change of the law, it will be very difficult for a judge to just sit and render these judgments online without...
So are we saying that the Chief Justice is asking for something illegal?
The Chief Justice, it's not illegal per se. What he's actually saying is that if there is consensus amongst the parties that you can deliver this particular ruling based on the circumstances through technological mode, then that is acceptable. And that is why, for any judgment, the judges are asking the lawyers, are you and your clients comfortable for this kind of mode of delivery? If one party is not comfortable, then the judge cannot do anything. And what the Chief Justice has directed then will actually be illegal if it is forced when a party
is not
does not
comfortable.
agree,
So
and the law has not
who
been amended.
determines the comfort? Because at the end of the day, excuse me, this needs to be done legally, but who is that determiner of comfort? We would imagine that the law is so clear that it has clear guidelines. If it is delivery of judgment, it must be done in this way, such that if it is being done by mail and there are questions that need to be asked or rebuttals that need to be given, then there is room for that.
There is room for that, and the law is clear. It has not been amended, and amending these particular laws in terms of procedure will then have to take its own course, which will not be done within a day. And they are very salient, like I've told you, there are very salient reasons why it is important for parties to be notified and to attend, such that, like I'm indicating, any push outside a consensus from the parties will then be legal, and in the fullness of time, it will be challenged.
All right, so do you find some of the deadlines given by the Chief Justice practical? For instance, he has given that all pending judgments and rulings must be delivered by 30th of May.
They are absolutely impractical. That directive alone is illegal. He has no power under any law to give such a direction. And the reason for that is this particular LSK has been pushing for courts to resume. I can tell you, judges are sitting and magistrates are sitting from morning, and remember that is they prepare from 8, court starts at 9. Many of them are going way into the afternoon hours. You are already having this particular directive that by end of May, judgments and rulings must all be delivered. That may be so. They may be forced and they may deliver. The question that then comes up will be, what will be the quality of these particular judgments and rulings? It will only lead to numerous appeals, which will then bog down the Court of Appeal and will then be counterproductive in terms of what the CJ would have wanted and the interest of justice. Judges plan their work. They plan them together with the advocates and the litigants, and you are told you'll get your ruling on this day. If there is a chance like what has happened and the judges could have worked on certain rulings and judgments, and they can actually bring them earlier, and they give notices, and all parties are told, yes, your ruling is ready. But you cannot give a blanket deadline and say that all rulings and judgments must be delivered without any power to do so. Okay,
so where is LSK and what's their stand? What is it that they would have it do? Open courts?
LSK is an association I belong to, and they have rendered themselves clearly that they will want a resumption of this, and if need be, open courts. But they have not specifically said it must be open courts. All they have said, and I've had the president reiterate time and again, is that what he doesn't want is that people are sitting back at home, advocates are sitting back at home. When you have cases, you have to only file them maybe online, and it's very difficult to actually operate when even the judiciary, in terms of the staff, is not back, is not actually supporting. What the president is saying, our president is actually saying is, let's find a formula whereby we will now gradually upscale, looking at all the measures, all the interests, all the concerns, so that we try to move it forward. But let's not just sit and wait for a day that this pandemic will end. And we have already been advised that it may well be with us maybe from 8 months towards even 1 year or past. Will we sit back and look at and say that justice will take a back seat just because of a pandemic? Implementation of even these rules being given, and has been rightly quoted by the High Court in the case filed by LSK, would have a central impact on rights of individuals. Those rights can only be adjudicated in a court of law, such that this court of law then, without it, it means it is injustice to everyone, including, and it will actually include each and every sector of the economy, which will rely strictly on what the courts will do in terms of adjudicating over commercial disputes, civil disputes. Every sector of the economy actually has an interaction with the judiciary. You cannot postpone that.
Okay, and okay, LSK has claimed that the reopening has been delayed, and this is, according to the president, Nelson Havi, a barrage of excuses that the judiciary has. Do you agree that this is being delayed longer than it should be? And if it is being delayed, I'm sure you understand that, of course, the times we're in, there cannot be that gathering. What solutions are you offering that now judiciary can say, okay, this is how we can start, even if it is starting with certain courts at certain times?
Indeed, LSK was right in terms of trying to push for a resumption, because what we had gotten from the National Council on Administration of Justice, from the 15th, a month later, they were just saying that we'll still, in fact, they started saying that they'll reduce the numbers. It came to a total shutdown of the judiciary. Then later on, after LSK started making complaints, then they said that we will gradually try to resume. There was no formula of how they were going to resume. At no point in time before LSK started complaining were we being given a roadmap in terms of this is what we are going to do to resume to upscale. So that failure to do that, lawyers will not just sit back, knowing very well that they have a central role in the administration of justice. To that extent, the LSK gave its own recommendation, and that's the problem with that is that there was no consensus built in terms of the National Council on Administration of Justice, because they seemed to speak with one voice, our council will speak with another one. But all they were trying to say, in terms of LSK, was that there are other innovative ways of trying to upscale the administration of justice in a way that we will still uphold the government directives in terms of social distancing and all the other directives which will assist and prevent the spread of this particular virus, both in court, both in the registries, and actually in the court corridors themselves. So that LSK had indicated that assuming you want to have an open court, we have a very big distance from where the judge sits and the tail end of the court. You can actually restructure that court so that advocates and litigants do not have to sit in front. You can restructure it to have only the matters that are actually live in court. You'll only have a single matter live in court at every given juncture, so that if we start at 9, you know up to 9:30 we'll have this particular case. No other advocate will actually be in that court. You can reduce the numbers of litigants where they are represented by advocates in court. To that extent, with a consensus and being rational and reasonable from both sides, there will be a proper structured upscaling of justice that will not infringe on the set guidelines by the Ministry of Health.
All right, in your opinion, why do you think then there is resistance from the judiciary? Why can't this be done? I mean, when you put it across, it sounds very simple, like something that can be done. And even if not immediately for all courts, it's something that surely can start in some of the bigger courts and maybe still continue deliberating on this.
The problem is, and as I'm telling you, lack of consensus, consultation, to a point that the National Council on Administration of Justice sits, makes a decision that we are going to upscale without communicating to the stakeholders, that is the judges, magistrates, and everyone, in terms of what are they going to do. Like they are very serious and rational concerns which were raised by the Judges and Magistrates Association and the Staff Association, which obviously needed to be looked into. What the CJ would have done is to say that we are going to upscale, but in the upscaling of this particular service, we are going to take all your concerns, and indeed, like they rightly said, MOH would have done a review, and this was a recommendation done by a recommendation which was given by the Judges Magistrates Association, which had not been factored by NCAJ, so that it was very important for MOH to audit all these courts, give a recommendation, and give a green light to certain aspects which we are going to resume. Failure to do that, no judge will then be comfortable knowing that this disease afflicts them as an individual, will go back to their family, they interact with all this judicial staff. And if I can tell you for a fact, we will not have been doing this, and we'll have just had an opening of the courts, upscaling like the NCAJ had indicated. I can tell you that disease would have afflicted judges, magistrates, lawyers, and litigants in a way that all the efforts that MOH and the government have been doing will actually be rendered null and void.
Null and void. All right, moving forward, of course, there's what we're now calling the new normal. And what do you foresee? This should be a lesson for us to learn, even within the courtrooms, of maybe doing things differently. Maybe this is an opportunity for us to use technology more and ensure that even after, even post-COVID, we are able to decentralize some of these things and operate from wherever we are.
That is the benefit that we are actually getting out of all this particular pandemic, because and it's something that the lawyers, judges have always been saying, that it was important to digitize the courts. And this is not only going to be about the courts. Each and every other sector. You've seen Parliament has also had to try and deal with its digitization mode, to an extent that you'll find that if we were to have gone fully digital, it will save a lot in terms of finances, it will save a lot in terms of time, it will save a lot in terms of resources, and more importantly, it will also help in terms of the quick administration of justice. It is a plus to us. We have been forced to do that, and I'm sure everyone in lawyers, judges, magistrates, and the clerks will then have to improve in terms of their IT savviness, to a point that even after this pandemic, this will continue to be the norm, because we are advised that maybe after another 10 years, after another 15 years, another pandemic will be with us. The next time it will come, the doors of the judiciary will not be shut, will not be having this particular debate. We will be ready for it.
And also, even looking at just pure expenses and things like that, do you feel like Kenya is digitally ready to go that way, as much as we're being pushed and forced to go that way now by COVID-19? Do you feel like we're making reasonable strides towards getting there?
Indeed, we are making reasonable strides, only that now it's like it's a forced kind of system. But the reality is that we have always known that we need to digitize, we need to have taken certain steps. The Jubilee administration came in saying that it's a digital administration, it will give laptops to all these children, to a point that by now, if that will have been implemented, we will not have an issue with schooling, we will not have an issue with deciding whether we'll have exams or not, we will not have an issue with dissemination of reading materials. And the same will then have set pace for all these other sectors, and we will feel like we don't want to lag behind. To an extent that if all this will have taken place, we will be comfortable. But I can tell you today, we still have a lot of challenges, both even in the court system itself. You'll find that you are connecting, trying to connect with the court, trying to connect to prisons. The connectivity has a problem, to a point that I think even after this, once that is developed and we deal with these challenges, it will then be a plus to all of us as a society.
All right, as you wrap up and give us your closing comments, what advice would you give to anybody who possibly has a pending matter in court? Here, the CJ has said that these judgments must be delivered by the 30th of May. You from the LSK feel that that may not be practical, particularly if there's coercion or being forced. What advice would you give to that person who's waiting for that judgment?
Indeed, there has been communication that if you have any pending matter, any pending ruling, any pending judgment, there is constant communication coming from the courts. It is being delivered online, mostly to the advocates. And if you do not have an advocate, chances are high you are expected to contact the judiciary through the executive officers or deputy registrars. The numbers are always provided, and you will provide your email contacts, and the court is very consistent in terms of communicating with you. You can put in your question, you can put in your issue, it will be communicated to the judge or magistrate handling your matter, and you'll actually get a specific date, specific time where your matter will be handled, or a judgment or ruling will be delivered. There is that communication, and they should not worry about that.
All right, thank you very much, Duncan, for joining us this morning. That's Duncan Okachu, who's an advocate, and just weighing in and seeing what we have in front of us in terms of matters judicial. So that's where we're going to wind up this particular interview. Thank you for joining us this morning. For now, we're going to take a short break, but a quick reminder of that question where we are asking you whether you feel government is doing enough. Has government adequately addressed the needs of people living with disabilities in its strategy to deal with COVID-19? For now, we take that break. We'll come back with news and reviews, but also that interview with Honorable Danita Gatti, who Trix Ngado is going to be posing some of these questions to. For now, we take a break.